Good night, ladies and gentlemen, wherever you are. Thank you for joining, letting us into your homes and wherever you are at this time. Whether you're watching us on NTN television, channel 69, whether you're watching us on Facebook Live on one of the various platforms or the PPPC's page on Facebook Live, I encourage you to share the link with your friends and share it to people so they can join us as well. If we take a little while and just share it a little bit, see who else, get a few people to join. Seeing some of the people online, Amjad, good night. Becky, Anne, thanks for joining us. On tonight's Thursday agenda, we're going to have a slightly different approach because of some of the things that have happened this week in and around Parliament. And I think it might be a little useful that we go through some of what happened. Parliament, the last sitting of Parliament was on Monday last. And at that sitting, as we all know, as seems to be the thing that the opposition does quite frequently is they walked out of the House, they absented themselves and made wild, unfounded, unfair, and unreasonable accusations about the Speaker. Now, there are things that we should get out into the open about how Parliament operates so that people could understand what happens. Parliament effectively operates as a court. In fact, in theory, it is the highest court in the land. It is a lawmaking body. That is the principal function of Parliament, to make laws. The legislature, to pass the laws, to bring those laws into effect, to bind the country. But the Parliament, there are the political parties there, and then there is the Speaker. The Speaker in Parliament is effectively the person who controls Parliament. He is like a judge. He makes his rulings, he gives his directions, he says what should happen, what should not happen, when it should happen. This is the role and function of a Speaker. This is what the Speaker of the House does. Now, the Constitution provides that Parliament will regulate its own conduct. And the Speaker, as we shall say, the person who is in charge as what's going on in Parliament, he is the decision maker as to what happens with conduct. Now, what transpired on Monday was this. The opposition leader, under the heading on the agenda of matters of urgent national importance, he wanted to raise an issue of the voters list and his assertion that the voters list was padded. First thing, the voters list is not padded. The voters list is in accordance with our laws. So that's the first thing. The second thing is he wanted this to be on the agenda for discussion as an urgent matter of national importance. Now, put this into context. An urgent matter of national importance is something that should be dealt with immediately. During the pandemic, there were instances during the coronavirus, during the floods, there were other instances that those sorts of things would qualify. But addressing the voters list and harping on about the voters list can't qualify as a matter that was an urgent matter of public importance. And who decides this? it's the Speaker who has to look at the rules. Parliament has standing orders, so he will look at the rules and he will apply it. He decided that it was not a matter of an urgent matter of public importance. But ladies and gentlemen, understand this. The Constitution is clear about the voters list. Residency is not a requirement. We've been through that a few weeks ago as to why. Not a requirement. So the list is in accordance with the Constitution of Guyana and the laws of Guyana. Bearing in mind that if you want to change those rules, you have to amend the Constitution. And the irony of it all is the first bill that Parliament was debating on Monday on the agenda is the Constitutional Reform Bill. That was the first bill. So, Mr. Norton raises a rather preposterous, unfounded, non-compliant would be the best term, but I don't want to get too technical. You have to qualify as an urgent matter of public importance. It did not qualify. The Speaker thought it did not qualify. There were 7 bills on the agenda to be passed that day. You all know, because you see it every day, that we are often in Parliament until 10 o'clock in the night, 12 o'clock in the night, until the next morning on occasion, because we have to get the work of Parliament done. The debates have to be completed. On Monday last, everybody who was in Parliament, the opposition was not present except for Mr. Schuman. We got home, we left Parliament at midnight. Now, these are all 7 bills that had to be addressed and had to go through its paces. Second reading, debate, into committee, third reading. All of that had to be done for 7 different bills. Some of the bills, as I will come to a little bit, were groundbreaking, were bills that changed the landscape in Guyana in a very significant way. But Mr. Norton wants to talk about a bloated list when there is no bloated list. There is a list in accordance with law. His administration, the opposition, they were in government. In 2015, they won the elections on that list. In 2018, the local government elections were on that, using that same list. Then, in 2020, those elections were on the same list. Now, it doesn't suit him, and he wants to talk about something. It's just rabble-rousing. He's just coming up with something that he's put no thought, little or no thought into. Notwithstanding that, following that, the ruling of the Speaker, they walked out. The first thing we discussed in Parliament and debated was the Constitution Reform Bill. Now, ladies and gentlemen, just to tell you briefly, we all the political parties in this country have campaigned in their manifesto that there will be constitutional reform. And constitutional reform is required. We're not going to doubt or debate that. Constitutional reform is required. There are areas of our Constitution that need to be amended. But for us to amend it, there is a parliamentary subcommittee, the Constitutional Reform Committee. That committee would usually have a bigger body. They would co-opt persons, if you want to put it that way, to give advice, because there has to be wide consultation. The last time this was done, when you want to do a comprehensive reform, this is what you would do. If it was just 1 or 2 pieces, then the committee would handle it. But the last time this was done it took 3 years, 1999 to 2002. There was a constitutional reform. Now, to make that committee, that commission, Constitutional Reform Commission, operational, you have to pass a law, a statute that says who shall be the members of that commission. So that wide-based commission must then have consultations across the country, have consultations with various sectors of society, various communities, and they must make recommendations what should be amended. Now, briefly, the commission will have 20 people. There will be equal number of government MPs and equal number of opposition MPs. 4 will come from the main opposition, 1 from the join the list. Then they will have representatives of civic organizations like the Bar Association, the religious Hindu, Christian, Muslim organizations, the Tushao Council. I couldn't name all of them, but that's the makeup. But then they're allowed to co-opt persons into the commission, like ordinary citizens, experts in various areas, who could all make contributions. You can write in your contributions, or you could attend the hearings and let your voice be heard, so that the amendments to the Constitution that will be produced as a result of this process reflect the will of the Guyanese people. That's the target. The target is the Constitution must represent the will of the people, and that's how it's done. But having said that, or not having gotten his way, like a spoiled child, like when you're a child, you play in cricket, you're out and you don't want to give up, you pick up your bat and ball and you leave. That's what Norton effectively did. No engagement. So all of the supporters of APNU AFC are left without a voice. What to say? There is no contribution from them in relation to constitutional reform bill. The bill was passed. That commission is going to be appointed, and the work of that commission is going to start. There is provision for the funding in that legislation of the commission. And those are things that are real, tangible things that should happen if we are going to get any better and if we're going to move forward in amending our Constitution. We have to understand, we can't just wake up and say we want this amendment in the Constitution. I might want to amend provisions as it relates to the right to property. You might want to amend relation to the right to life. Another person might want about right to access to the courts, right to work. Everybody might have different things. And we can't all have what we want. That's not how democracies work. But if you have broad-based consultations and discussions as to what are the essential parts, what are the parts that you want to have there, then you can have a real opportunity of engagement, and you arrive at a consensus. And that's how the Constitution will move forward. Now, all of it we must understand. All of it commences in Parliament with an act. Opposition's not present. Now, that indeed was a sad day that they would not be present. But I'm a member of the Parliamentary Committee, the Constitutional Reform Committee, and the opposition members were often not present. They didn't provide contributions, recommendations. In the end, they simply went along with what the governing side had recommended and say, well, they will go with that. They were given umpteen opportunities. So you could see who's actually saying, walking the walk and talking the talk. So you say you want constitutional reform, but you participate at no stage of the process, then you're not really telling the nation the truth. Now, that was one aspect of what transpired on Monday. For those of you who would be a little bit more legally inclined, and I would like to just address a very important bill that was passed into a law, which is the Bail Act. Now, for those of you who are in criminal practice or associated with the courts and the legal system, you will know that everywhere else in the Caribbean has a bail act. And we needed to have a piece of legislation that sets out and dictates what are the conditions for bail being granted, what are the conditions for bail being refused, how to appeal bail, where to appeal bail, how do you go further. We need to really do that. We needed it. Now, I've been in practice for 25 years, and as I've said before, this is the most significant change to the criminal justice landscape in this country in my time as an attorney. It sets out very clearly the provisions of when you are granted bail. It puts the considerations that the court, the magistrate, the judge, the Court of Appeal, the Caribbean Court of Justice, what they must take into consideration. Importantly, I think, what it says about the granting of bail by policemen, which is a much vexed issue in this country. It is something very important, and it is now being addressed. Now, the truth is, as I was coming across here today, two people stopped me to ask me about being detained by the police and what happens. It is a much vexed issue. It is a much, right now, it's a hot topic, if you want to put it that way. But you got to understand a little bit that police powers should be exercised as every public official exercises his powers, reasonably, not capriciously, not without regard to your public duties. Now, one of the things that is important is, by law in Guyana now, by Section 4 of the Act, if you are arrested and you're taken into custody by the police, and the offense for which you're being arrested does not carry imprisonment, or for which you're in custody, the police must release you with convenient speed. Now, that is what the legislation has been put out to be. Now, this is why the legislation and putting the legislation into effect is so important. And this is why the importance of such a bill. With every convenient speed means, once you know that there is no imprisonment for the offense, a lot of the traffic offenses do not carry imprisonment. Once the police is aware that this is what he's charged with, there is no imprisonment, you're not waiting for the superior officer, the arresting officer, the boss, the friend. You're not waiting on any of that. You have to act with convenient speed. You've become aware. In other cases where it is not a serious offense, serious offenses are offenses that carry imprisonment for more than 5 years. If it's not a serious offense, then they must do it as soon as practicable. Soon as practicable also has a meaning. Not quite convenient speed, not quite what happens if there is no imprisonment possible, but it is now clear that they must do it as soon as practical. So they can't just laze around, sit around, decide, deliberate, push you around. The law now gives you rights, and if they don't obey those rights, then you can take proceedings for the enforcement of your rights now because of what it is. So bear in mind that this Bail Act, which is so important, again, the opposition is not present. I don't want to belabor this because it's almost strictly a legal issue, but it's things that people should know. One, as long as it's not a capital offense, that is murder, or an offense that carries the death penalty, as long as that, you have a right to bail. That is the starting point of the discussion. Whether it's in police custody, magistrate court custody, high court, you have a right to bail. And it is only if you behave in a manner that they must deny you bail. So how do you behave in the manner? You're interfering with the witnesses, you're a habitual offender, you will interfere with the case, you will not give your address, you will abscond and run away, you don't want to say where you live. It's only if those things happen, then you will not be granted bail. So again, these are the matters that the court, it's listed out. So what used to happen, unfortunately, up until this legislation, is persons, you would go to one court and you would get a magistrate giving bail for this offense, and for the same offense, half a mile up the road, a magistrate refuses bail. Now, that would happen in the magistracy, in the High Court, in the Court of Appeal. You would have that happening too frequently, because there would just not be any parity. There would be no equality of the application of the law. Now, it's not really the fault of the judicial officers, because they might all be taking different considerations into being. They might be relying on cases from different parts of the world. They might be relying on principles that they have in their mind should be relevant. And of course, the downside is not many decisions are being reported frequently enough in Guyana. But what this legislation does now is everybody's on the same page. So the same principles that are being applied in the Magistrates Court, High Court, Court of Appeal, Caribbean Court of Justice, everything is now uniform. Everybody knows what principles must apply. Everybody knows what must be taken into consideration. All of it is set out very clearly in this legislation. And when you are denied bail, importantly, the decision about bail, it must be written down and given to you. So you will have the reasons for that denial. So you can take further proceedings. You can appeal if you so choose, because the Act provides that you appeal to the full court, then to the Court of Appeal, then to the Caribbean Court of Justice. Those are your steps. Most of Guyana, because of the election fiasco that we witnessed a few years ago, know the appellate system very well. But in these proceedings, you also have the right to do judicial review, meaning you can go to the court and review the decision to grant you bail, and to say that whether it's too much, too little, wrong considerations, ignored consideration, you can go review the decision. So not an appeal, a review is provided for. So you gotta understand, ladies and gentlemen, this did not exist. These things were always trying to figure out based on case law and based on legal principles. When it's now set out, it's now a much more even hand. It's now litigants or defendants know what their rights are. The courts know what rules to apply. The defendant knows what rules are going to be applied, and whatever the outcome, it will be written and given to him. Now, make no mistake, ladies and gentlemen, this legislation is groundbreaking. It is a landmark piece of legislation that was desperately needed in Guyana. And the addition of this act to the judicial system of Guyana is certainly a credit to the Attorney General. This piece of legislation will go so far to preserving liberty and the right to liberty in this country. This is important. And again, on all of the debates and all of the consideration of this bill and all of the provisions that give you rights and demarcate very clearly what takes place, the opposition didn't think that it was a good idea that they be in Parliament to contribute to this. So that's pretty much the tenor of what took place on Monday. Now there is one other piece of legislation. There was other legislation that was passed that was very important. The suicide bill is now an act. Very important. We all know that in Guyana, this is a matter of great concern nationally, and this was a problem. So we know that this is an issue. That bill was passed. Restorative justice bill was passed, which provides for a more peaceful resolution of disputes of a certain nature. Again, important pieces of legislation that were not addressed or dealt with in the presence, or contributed to would be the best way to describe that, by the opposition. Now, additionally, the last bill that was passed that night, all the way into the night, the late hours of that night, was the Narcotic Drugs and Psychotropic Substances Control Amendment Bill. I just want to go through with you just briefly. Now, we all live in a country that we must respect the views of others. And what this bill went to a select committee, and there was wide consultation about the views of persons. There are people who feel strongly that marijuana, cannabis, should be decriminalized and there should be no offense. And there are people who feel very strongly that it should be a criminal offense, no matter the quantity. So these are the two competing things. One of the things that I want to say to you is this. It is now vogue, or in vogue in the developed world, that marijuana is legal. It is legal in many states in the United States, Canada, parts of Europe. But up until the 1970s or thereabout, marijuana was not illegal in Guyana. And we passed legislation in the 80s to make all of these things, these various things illegal. On pressure from in the 70s, there was also offenses related to it. In the 60s, some of it, but not full-blown regime of legislation until 1988. But how did that legislation come about? That was under the enormous pressure of the developed world. The same United States, Canada, the developed world, there was the Say No to Drugs campaign, the war on drugs, all of these things. That was the slogans that came up. But now those slogans have been replaced by slogans in the same part of the world as to free the weed and legalize it and all of that. And we have to admit that we are reacting in some ways to the views and the pressures that come from the developed world. Not necessarily political pressure, but pressure of the people and the norms that are there. We want to transcribe them here. So we have to be careful about that. And we have to recognize that Guyana, we have to respect the views of each other. We can't ignore each other's views. So we got to come to a consensus. We got to come to a middle ground to a position. Everybody is not going to get what they want. You know the saying, you could, some of the time, you could fool some of the people, some of the time, all of the people, but you can't fool all of the people all of the time. I think you could say it relates to this. You could please some of the people some of the time, but you can't please all of the people all of the time. That's just not going to happen. So what is our law at this stage? So if you have up to 30 grams of marijuana, there is no imprisonment. So that is because the problem that was being faced in Guyana and the mischief that we are remedying or trying to remedy and trying to deal with The mischief of it is that we have too many young people who, for minor young and old, but mainly young people, for small quantities of marijuana, who are being imprisoned for 3 years because that's the mandatory penalty. So we have too many young people being imprisoned for small quantities of marijuana. It puts pressure on our prison system, but it does worse. It destroys those young people's lives, and it puts them into prison among hardened criminals. It's like going to a university of crime, because those become your friends, those become your peers. Now, that's a very dangerous thing, and that has long-term effects for criminal activity, and that has long-term effects for a life of crime. Now, at 0 to 15 grams under the present legislation in Guyana, what will happen is you will have to have counseling. That is compulsory. You are compelled to have counseling about your drug use. And that's what the court will order you to do. 0 to 15 grams. 0 to 15 to 30 grams, you would have to do community service in accordance with the regime that exists under our law. But there is no imprisonment for 0 to 30 grams. That is now the position that we have in Guyana. So we haven't removed, we haven't decriminalized marijuana. We have simply taken away the custodial penalties for small amounts of marijuana. Now that is from the consultations that were had and the views expressed by religious communities, Rastafarian communities. That was the middle ground that was arrived at. So those who will use marijuana, they now, of course, the emphasis is still to discourage it and try to persuade you that you should not be using marijuana. But those who do not have to go to prison for a joint, for small quantities of marijuana. So what has happened is it's not been decriminalized. It is still an offense. It is just the penalties that will apply. And the penalties are now very different. The removal of the penalty of imprisonment would have great, substantial, I would say, benefits to society as a whole. Because there's always the yin and yang. You will say, use of marijuana, there is addiction issues with it. Then you could say that the use of marijuana forms part of people's religion. You could say the use of marijuana promotes crime, petty crime, getting to the point where you sell your possessions, your family's possessions. The other hand, you could say that it has medical value, medical purposes. Then they could say you destroy families, you become a junkie, you're living on the street. You could then say that there are health benefits, especially persons claim at end of life stage and for end of life care, terminally ill patients. This is their only relief. So they're both sides. But what we have to learn and what we should accept is we have to be tolerant of people. Tolerant of people's views, tolerant of the views of others. You can't have your own way all the time. And please, don't be like Aubrey Norton. Because you don't get your way, you get up and you walk out. You pick up your bat and ball and don't engage. Don't do that. He was not, and as a result, his entire party made no contribution to this bill. But what we have to remember, as a people, we have to be tolerant of each other's views. Now, we want to move to a process, and their views expressed in various quarters, about all these issues, all these things to do with decriminalizing marijuana. and we can get to that process. But you can't, we have to go with the will of the people. If the people's will is at this time, don't decriminalize it, just make it that you don't go to prison for small quantities. It's still an offense, but you don't get punished with imprisonment. That's what we're doing. So it's still an offense, there's just no imprisonment for it. Now, we might, in the future, there would be different considerations from different consultations. We might make the amount larger for no imprisonment. We might decriminalize. I mean, all of these things can happen. But it has to be where the consensus point in the country is. We can't say, oh, I think this is what happens. How would we govern a country of 800,000 souls with every man having his own view? It's not practical. There is no hope if we embark upon that. So this is the consensus. It is a position which I dare say, my humble view is, it's a position that is far better than it was before, simply because small quantities, young people don't have to be imprisoned. So they got to go to counseling, they got to do community service. There are opportunities and avenues along the way now for them to be helped. So hopefully they may take advantage of that help. That is the hope. But where we are with the bill and what the bill is, the bill has now been passed by the Parliament, but this is where it is, and this is what we have to accept. Now, there is one other issue that really, I don't want to get too, or to say things that are too, or that are perceived to be too aggressive. But Minister Sonia Parag this week visited, as she does constantly, visited areas in Region 5. Now, the ministers of this current government, of President Irfan Ali's administration, the hallmark is they are out in the communities every day. They are not hidden in offices and inaccessible. They are accessible to the people. You know that is a hallmark of the Irfan Ali cabinet. Now, what happens is ministers go from area to area. You meet with the various communities. You meet at regional offices, schools. You meet at all the various facilities that are there. And you listen to what people's problems are. You try to address it. But you try to put programs. You try to implement programs. You try to give some sort of guidance where necessary. All of these things are necessary, and that's what the minister is doing. Now, Minister Sonia Parag went to Region 5, and an MP, a sitting MP, decides they don't want any help. The people there don't want anything, and the access to the building is being restricted. Now, if you see the reasons for which access to that building was restricted, you would laugh. There were issues of, they said, vandalism not reported to the police, that they said that there were things to be done, they hadn't taken an inventory, but they told nobody of this. Now, for doing that, a minister comes, a female minister, but that shouldn't matter so much, but it'll be relevant to what I will say, but a female minister comes to a village for where they have been recently, in the recent past, there have been issues, there have been social unrest in Belladrum. And she went there to do her job. But that sitting minister, Vince Roy Jordan, he obstructed that, her duties being carried out. He obstructed the engagement between Minister Parag and the residents. This was done, her visit was because of President Ali responding to say he had promised, and he promises across the country, where you make a request that you would like to meet a member of government or to meet the cabinet, or where they have been there, then they follow up to ensure that the issue had been addressed. So this was a request made to the president. As a result, Minister Parag was there. Now, he obstructed Minister Parag. He said foolish things like the people there don't need any help, or the young people there don't want any assistance, or they don't want any assistance from the minister, or they didn't want to meet the minister. It depends on who you believe. The substance, what he said exactly, the substance of it was he did not want the meeting to go ahead, and he did not want to permit it. Now, that's such a cowardly and foolish thing for a leader to do. It doesn't matter why or which side of the political divide you are. Your constituents, you must always help. You see, you adopt that foolish attitude when you have a leader who walks around this country thinking shaking hands with the president is somehow a thing that he wouldn't do. He feels as if he is being interfered with if he shakes your hand, or he's being oppressed, and saying all kinds of nonsense that he wouldn't shake hands of his oppressor. Your job is to put your silly ego aside. Put your foolish concepts away and serve the people that have voted for you. That is your job, your only job. Now, how do you serve them? You serve them by alleviating whatever problems they have as best you can. And part of that has to be done if the minister is there to hear the problems. Encourage them to come out in their numbers. Encourage them to list every problem. Encourage them to demand that it be fixed in a timeline, in a fixed period of time. Demand responses. Don't be an idiot and say, oh, well, we're not going to talk to you. How are you going to how are the people going to benefit? How are they going to get help? I mean, the MP is fine. He might be able to look after himself and he doesn't need any help. Well, lucky him. What about the people who voted for him? What about the people that he's denying this access? But you see, he thinks that's a reasonable thing, because the other one thinks, the opposition leader, that if he shakes someone's hands, it somehow affects him. You see, that's why leadership, ladies and gentlemen, that is why leadership is important. You have got to understand what service is. Serve the people, not yourself and your own ego, not your foolish concept of what's right and wrong. How could you do that? How could you deny an entire village because you're a fool? How could you do that? Deny an entire village. If something was wrong with the building, do something about it. Utilize it as best you can. Utilize where you can. Put up a tent outside. Facilitate so that the people who depend on you for representation and not left out in the cold and ignored and subject to your women fancy and your moods. Get them the assistance, any assistance that you can, any assistance. Now, you can't adopt principles and hold views that are so unreasonable and inimical to those who supported you. You do not deserve their support. You do not deserve their loyalty. Do not be fooled, because what you did that day, what Jordan did that day, was deny the people of Belladrum access to the minister for the assistance which they would have liked to have had. Whatever that assistance is, they made a request to the president. The president sent his minister so that that request could be addressed, so that those needs could be met. And here comes a very clumsy clown, and he prevents it from happening. There could be no excuse, and the people of Belladrum should accept no excuse from him for what he has done. He has denied them the opportunity to access assistance that they very dearly need. He said nothing about that. It is all about what he did and what he didn't do. He's made some statements about it. But the crux of the matter is, you didn't allow, you didn't facilitate, you didn't accommodate, and you didn't get any assistance for those who depend on you to speak on their behalf. What a crying shame. Now, I sincerely hope that people are not going to be duped into believing and relying on leaders like that moving forward. Remember, there's local government elections coming on March 13th. And on that time, vote for the leaders who will stand up for you, who will put aside their egos, and who will shake hands with everybody so that you get what it is that you would like. Ladies and gentlemen, thank you as always for sharing your time with me and joining me tonight. We started a tad late, I know, but those were matters beyond our control, and that's all right. We're going to be here, same time, same place, next week. And as always, good night, and may your God be with you.